communications recording rules have been in place for FCA, FSA registered firms for a long time now. From our perspective, there's probably kind of three main reasons why these rules are in place. So firstly, to strengthen investor protection. Secondly, to improve market surveillance. So it's probably that fraud aspect in that. And then also to increase legal certainty. So if you don't have the communications being recorded somewhere, if a client says, no, this is what I said, if they're not recorded, then there's no certainty as to actually what was said. So it doesn't need to have fraud. And as Wendi says, the rule is you must record.
I think we've seen the beginning of this, and we're going to see more and more actions that banks and broker-dealers will be taking against employees, because obviously these fines that are so enormous are going to have a tremendous domino effect. And I think that there are probably three major areas. Employees will be, number one, reprimanded for this off-channel communications, even if they weren't aware that they were doing anything wrong, even if the company had a policy that they were not made aware of. Number two are terminations. We're going to see, and we have seen, terminations not only for cause, but also merely breach of policy. If a company has a policy, and even if an employee is not made aware of it, as I said before, the policy exists that these off-channel communications are not to be used for business purposes. And if they do, they're breaching a policy. And that alone is cause for termination under most offer letters, under most contracts. If you're terminated, the organization compliance files, what's called a U5. This U5 will follow you, because any regulated bank or company can go online and look you up and see why you left. And this U5, they call it a dirty U5 in the industry, if in fact you're fired for cause, or if you're fired for other reasons, which could be having nothing to do with your performance as a broker, but could be a breach of policy again. And so these issues are really thorny for the employee. This is an industry, as we all know, that people do not join easily and get up at 4 o'clock in the morning because they're getting paid millions of dollars in salary. The bulk of their compensation comes from their incentive compensation. It's not just a matter of contracts anymore, although offer letters and contracts do have clawback provisions. But now you have a regulatory piece of that, which is the SEC and FINRA and the Commodities Futures Trading Commission are saying, you must claw back incentive comp when there is wrongdoing. You're going to see tremendous clawbacks in this arena.
Firstly, you have to audit your policies and procedures to ensure that they comport with SEC and FINRA's rules and regulations. Policies alone are insufficient. You must ensure training of your employees with an annual attestation. Throughout the year, you should be sending reminders and emails, webinars, seminars about your record-keeping practices. Of course, the firm has to maintain and preserve the off-channel communications. Ask yourself, do you employ an experienced and knowledgeable vendor that's capturing and preserving these communications? And are the communications easily accessible for an audit and for a review? Have you issued company phones to your employees? For individuals who are using their personal phones, and we have to be realistic, this occurs, you're using your personal phone to communicate with clients or colleagues, do you have a system in place to transfer those communications, those electronic communications, to the firm's server so that they can be preserved? You have to also ensure training of your CCO, your supervisors, your executives. The tone at the top is very important. You should also regularly review SEC and FINRA rules and guidance, including these recent enforcement orders, to ensure that your policies are updated.